Very happy Wednesday, April 23rd, everyone. Spring is here, and so is our Advisors Forum, part of the Elville webinar series. And I'm Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's presentation. Today's topic is Bulletproofing Your Estate Plan, dealing with long-term variables in estate planning. And your presenter today is the one and only Stephen Elville, Managing Principal and Lead Attorney of Elville & Associates. How you doing today, Steve? Doing good?
I'm doing great, Jeff. Thank you for the wonderful weather.
So just a few housekeeping items. You received the presentation slides by email from me yesterday, if you'd like to take notes. And the slides are also available in the section marked handouts on your screen to download at this time. We have a lot of advisors here today, so welcome. For CFPs, CPAs, and most everyone else, as is the case with most all of our presentations, we do offer continuing education hours for attending. And if I don't have it already, please email me your ID number or an accreditation so I can submit your CE hours for approval and also send out certificates as appropriate. And we welcome your questions. Please note them in the questions panel on the chat or the questions panel, and we'll pause periodically to address them. And everyone will also receive a post-webinar feedback email right after the presentation. So please take just a couple minutes to fill out this brief survey and offer us your thoughts about today's presentation. We have so many great things going on here at Elville & Associates. I'm very proud of, more than we can even begin to share right now, but just a few highlights. Our new Montgomery County office at 1700 Rockville Pike in Rockville just celebrated its 1-year anniversary, and it's a beautiful office. Lots of room, beautiful artwork that is a lot of originals. So stop in and visit anytime. And the firm also continues to grow in size and scope. We have 2 new attorneys that have joined the firm recently. So they work very closely with Steve and advise on all different types of matters. So look forward to introducing you to them as well. And we've added a monthly advisor newsletter you're going to receive on the 25th of each month, starting in 2 days. So keep an eye on your inbox for that and let us know your thoughts. And lastly, our biggest event of the year, our annual client and community education event, is set for October 18th at 10 Oaks Ballroom. And we had a capacity crowd again of 300 last year. So details are going to follow shortly. And it'll be a capacity crowd again. So please RSVP early. And as for you, our advisors, you're very important to us here at the firm. We always work to be collaborative in a planning team approach for our clients' best interests and yours. And we always work to maintain the highest levels of trust and confidence. And we want to help you protect, keep, and grow assets under management for your practice. We welcome the opportunity to connect with you or reconnect to discuss best ways to accomplish those goals and ideals. So I want to share just a brief overview of the firm and Steve, and we're going to jump right into the presentation here. So you should be able to see my screen here. So we are Elville & Associates, founded in 2010. I've been here for almost 12 years at this point. Founded by Stephen Elville. We have many different practice areas that we focus on a daily basis, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning techniques and asset protection techniques as well. We now have 12 attorneys, including our of counsel, 10 staff members, and 3 locations. And our mission, it's always been the same since we started and always will be, and it is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus on education a lot here, as many of you know, and we do that in several different ways. Just a few of them are through our planning processes with our clients. And we have different programs to suit all families and individuals here at Elville & Associates. We also offer many educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only a couple of firms in Maryland to have a client care program accredited by the Client Care Academy up in Boston. And we always work with the ideals of client education, collaboration, and compassion in mind with every client every day here at the firm. And just a bit about Steve. Great leader, great attorney, great friend, great manager. What else can I say? He's been an attorney for many years, focusing on elder law, special needs planning, and estate planning, a member of many different national membership and professional organizations, as well as different peer groups. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. And Steve's a very seasoned speaker. Many of you have heard him talk before. offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. And lastly, Steve was named to the Maryland Super Lawyers List for a 10th time and 9th consecutive year in 2025. So congratulations there, Steve. We'll see what 2026 comes, what happens with that. I'm pretty confident though. And Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization Steve founded in 2014. I'm very fortunate to be a part of. If you'd like to learn how we work to make a musical difference in the lives of children each day, please reach out to me and I'll be very happy and pleased to share our story with you. Steve, I'm going to go ahead and turn it over to you. I'm going to make you the presenter.
Jeff, thank you. I'm going to have to get you a golf certificate or something. Thank you.
First, I need to get to the driving range, Steve.
Driving range. Okay. All right. I'll try to limit it to the driving range. Hang on just a minute here. I'll get myself situated, get my slideshow started. Jeff, thank you for those kind words and for all your support and all you do for the Advisor Forum and so many others. Good morning, everyone, and happy Wednesday. And I know you could be anywhere this morning and you're here with us. We're going to make it worth your while. We know your time is valuable. I'm going to be as efficient as I can. I'm looking out my window here. What a beautiful day, even though we recognize that many of you are doing a lot of juggling and keeping your clients, centered amidst everything that's happening in the world and the country and the economy. So we understand that, and we are thinking of you and what you have to do each day to keep your clients kind of centered and not worried, and keep going with what you do despite all the goings on in the markets and so forth. We are cognizant of your need to, provide great client service and keep assets under management, and to have great relationships with your collaborative advisors. And that's what we want to be, as a resource for you and help you to do the things that you do. And we appreciate that you are so dedicated, many of you, to, I hear this all the time. I get messages from advisors that say, Steve, I follow your advisor forums and your educational workshops, and it's really such a privilege to be able to help you with continuing legal education. But we learn from you as well, and we know that you are involved in many different aspects with clients. And we also realize that for many of you, you are their client's most trusted advisor, along with CPAs. So we're just privileged to be here, to be a resource, and to be part of what I would call a collaborative team. In addition to what Jeff said, and we're going to get into the material, I wanted to let everyone know on this webinar that Elville & Associates has a wonderful business attorney co-counsel relationship with Francisco Mundaka. Francisco Mundaka, if you have any business-related legal issues, we are very pleased with what we are doing with Francisco, who is helping us help our clients who have business interests to be able to do many more things than we were capable of doing before. And for many of you who want your clients to have more education, which is what we're all about here, we are working with a videographer who's very talented, and we're going to have our educational platform on a Kajabi platform, as far as I know, and that's a project we're working on here in the next 3 months. So today, as you spend your valuable time with us, we want to make you have help you have a healthy awareness of this material. Jeff, for example, did you know your estate plan could be changed? Did you know that?
I did know that.
Well, I didn't think you did. Well, anyway.
Because I've been on so many presentations, Steve.
Well, I forgot about that. But I think the first time you heard that, I think you were quite shocked. And most people are shocked. And this material is coming down from, various types of professional material I have access to. And the estate planning world as a whole, the estate planning community, is coming to terms with this and realizing that not only do we have lots of tools that we never used to have, which we're going to talk about this morning, but that most people, mostly obviously clients, are not aware that these tools exist. And we all make the big assumption many times that these tools are good, that these tools should be used. but not always, because sometimes these tools can, if they're not properly used, they can actually change a client's estate plan, which is otherwise irrevocable, and they could be contrary or thwart a client, a set of intentions. So this morning, this is something that we want you to just walk away from with this general sense that your client's estate plans could be altered. They could be changed. And, while we want flexibility, I mean, flexibility to me is the key thing in 2024, now 2025 and beyond. We have to understand the scope of flexibility, and we want clients to understand this. So to just give you a brief example, Jeff mentioned our client care program. Well, we had our client care program event, I guess, a month ago now, and I was getting ready to present this same material to the clients. And as always, I was worried about, is this going to be something our clients are interested in? I was wringing my hands and things that Jeff knows that I do sometimes. And to my surprise, not only did we have a record crowd there, but people were extremely interested in this subject. So I think if you get a working knowledge about what we're getting ready to talk about here, I think it will be extremely important that your clients know this. And I think you will be giving more value to your clients, that they not only know that there's lots of flexibility now in estate planning compared to what there was 20 years ago, but that this flexibility has to be controlled, it has to be understood, and in some instances it may not be desirable. So we want to look at this and how to deal with long-term variables. Last thing I'll say is that we have workshops about being intentional, achieving perfection in estate planning. Well, those workshops are geared towards people who are super committed. They follow up. They are interested in achieving those things. This is similar. This is similar in the sense that someone who is a client of yours is going to be super serious about making sure their planning works the way they want it to work. For example, I was meeting with clients yesterday, two different sets of clients. One is a modestly wealthy couple. They wanted to make sure that their planning could not be changed based on a certain set of parameters that they've set forth. And then another couple that came in as a more higher net worth couple, they were not aware at all that these flexibility mechanisms exist, and were extremely appreciative to not only understand these variables that can happen in estate planning, but also just to be up to speed on Maryland law about spousal protection and Maryland estate tax and all the other things that are going on in the world. So with that said, and that long introduction, let's get into the material. And obviously this is for legal education only. It's not legal advice. It is not an attorney-client type setting, but certainly you or your clients could enter into that with us. And again, as we get into this material, Elville & Associates wants to be a resource to you, not only in Maryland, but multi-jurisdictionally, to let you know what is really happening in the multi-jurisdictional nature of estate planning, which we're going to get into a little bit today. So as always, we're going to be looking at trends in contemporary estate planning, but more in this particular silo, okay? We're going to talk about what clients need to do to stay abreast of change and what you need to do, obviously, as advisors. Some of you are CPAs probably as well. We want to talk about maintenance and updating, which we always talk about. One of the things that we can do to keep clients from, I guess, going over the edge of worry, with worry, and you are very, very cognizant of that right now, and so are we, for different reasons. We have many clients worried about the state of the world, the state of taxes, the state of Medicaid, the state of delivery of services from the government, all of the things that we could spend an entire hour on. Those are reasons to maintenance and update the plan, maintain and update. However, what we're really going to be talking about today is not only updating the documents, maybe because your clients want to become cognizant of a certain issue that could be threatening to their plan, which is really counterintuitive. We're going to be talking about post-mortem control or lack thereof. What happens after my death in the future, okay? I met with yet another couple yesterday who was extremely concerned about this particular issue. And of course, that had to do with a person with disabilities more so than many cases. What is the fiduciary succession? Who is going to serve after your client serves, their children are designated to serve, or their corporate fiduciaries are designated to serve? This fiduciary succession issue is a big issue. Clients opting out of some of these things. So this is going to make more sense in a few minutes. We're going to see a lot of changes that have occurred in the last 20 some years. But now, should clients try to actually opt out of some of those things that many estate planners think is a great thing? All of this flexibility. Coming to terms with these tools, and of course, questions and answers. So we're a little slow getting started here this morning, but we're trying to lay the groundwork for these next slides. So as we go through, please ask Jeff questions. Please ask me, Jeff, questions. We're going to be here and monitoring the chat. So to me, when we're thinking about the material in this presentation, we're really talking about, I think, two things mainly, and that is, if I do an estate plan, how can I make sure that it's not contested? You know, this is the age-old question, and many of you are quite familiar with this or have seen cases like this in your own practice that have affected clients and their families. So it's kind of like, how do I keep my plan updated and make sure that at my passing, nothing untoward happens, okay? And then there's the post-mortem issues of control and the flexibility that is allowed after someone dies. So let's get into this first part, which is, how do we deal with contemporary estate planning? And sometimes we kind of whisper about this no contest clause and what we call interim clauses. And as you'll take these materials and maybe use them as a reference in your hard drive somewhere or in your cloud, here we're talking about the intentional interference with somebody's estate plan and recognizing the different things that exist here. There's 24 states that recognize intentional interference with estate plans. Fraud and undue influence, we're dealing with that every day. Yesterday in a client meeting, we were talking about how a particular child could argue that her parents, when they came to do estate planning, were the victims of fraud by another family member or the undue influence of another family member. And of course, the law is pretty settled about the elements of undue influence and so forth. So these are kind of esoteric things, but where I'm going to go here in a few minutes is trying to be more definitive about this. So what is testamentary expectancy? What does your client really want? And what is the definition of that? And what is tortious interference? Okay, it's got to contain fraud or an undue influence allegation, okay? If not for the interference, the inheritance would have been received, and will challenges, and we have to prove the invalidity of certain things. So all of this could be a 2-day seminar just talking about this subject, but let's get to the point. In Maryland, the treatment of this type of thing, this interim no contest clause, is unclear. Surprise, surprise. It depends on the facts and circumstances. Maryland does not recognize something called a tort of intentional interference with testamentary expectancy, okay? And there are differences in the various types of contests or actions that can be brought. So I think that the beginning of this kind of knowledge is to understand that this is a sea of ambiguity across the country about interim clauses. Let's go to the next slide. Now, you could use arbitration clauses in wills and trusts, but only 5 states do that. And DC expressly prohibits this, and Maryland has not addressed this, but you can just open your minds to this and see that an arbitration clause might be used as a deterrent in a will or trust. This is the thing where a panel is selected by the fiduciaries and the claimant, and there are risks, right? Because the arbitrator's decision is final. But let me back up for just a moment and just say, you know, I'm going to clear up something about will challenges and trust challenges. I'm going to go back to the first slide for just a second. So the testamentary capacity necessary to sign a will is actually not very high. And when I was a much younger lawyer, I used to think that trusts were different, right? If you have a revocable trust, testamentary capacity, so to speak, is different. Well, that's not really any different, really. But what I think that most of us will recognize is a trust contest, somebody that contests a revocable living trust, which is a substitute for a will. Somebody that contests that is going to have some more hurdles to jump through. If someone contests a will, they bring a caveat action, they are bringing a challenge to a will, it's quite an uphill climb. They have to go through a process that is pretty easy to enter. If you're familiar with the orphans court, which most counties have a traditional orphans court, a few counties do not have an orphans court per se. They have a circuit court that acts as the orphans court, such as in Montgomery County and Harford County. But the concept is the same. If a person contests a will, it doesn't mean they're going to win. But let's pretend that they do win. Well, first of all, it's pretty easy to contest a will. You know, it's pretty easy. All you have to do is file a claim and say, hey, I am contesting this will. It's pretty simple to go through the front door. Does not mean the person's going to win. But even if they do win, then that can be appealed. So that win can be appealed by the other side, and the trial starts all over again, a trial de novo. So this is a long process to contest a will. Now, conversely, contesting a revocable trust is going to be a bigger climb, generally speaking, because revocable trusts are recognized by and governed by the circuit court. So the circuit court is going to, first of all, respect this revocable trust because it's a private agreement. The person bringing the challenge to the trust is going to have to jump through more hoops, most likely, because they are now going to have to bring a challenge under the formal rules of evidence, not just the more informal orphans court. They may or probably would have to have counsel, even though they don't have to. It's going to be more expensive and so forth. So there's lots of things to think about just from the beginning about wills versus trusts and the contest or the potential contest of these documents. So when we're talking about inter rerum clauses, most wills or many wills will have a basic no contest clause, but as I was talking to one client yesterday, we can greatly increase the substance of an inter rerum clause, and it is not necessarily unenforceable. I think many people feel that no contest clauses are unenforceable, but that is not necessarily the case. So we can bolster these no contest clauses in wills and trusts, among other things that can be done. Now, some people will say videotaping of a will or trust is a good thing to do. Well, that's a popular notion. I don't think there's anything wrong with it per se, but we don't typically do this unless it's a very, very special situation. It is risky. There is some risk that the video just was not well done. There's risk that it's not admissible. It can discourage a potential challenger, but then it's always about litigation. So Maryland allows the introduction of video about a taped execution, but it is subject to the hearsay rules. All right, let's get into this notion of the irrevocability of trusts. So obviously, trusts are created by grantors. They used to be called donors or trustors in the old days. But what we're trying to do here is we're trying to achieve the grantor's wishes, right? And you are keenly aware of this in your practices, and so are we. If we're not helping people achieve their wishes, then we're not getting a whole lot done. So for the last 20 years or so, I'm being very general here when I say there was no flexibility in estate planning. I mean, there was no such thing until in Maryland In 2014, there was the introduction of what is called the trust advisor. Here I've listed that same name as a trust protector, which is pretty much the same thing. However, trust protectors were in other states, such as Delaware and Nevada and Alaska, long before Maryland sanctioned the use of trust advisors in 2014. So 20 years ago, if I had talked to you, which I did talk to some of you 20 years ago, actually, we would not have the flexibility that we have today. So this whole webinar today is about the state of that flexibility and whether that's actually a good thing. So now we have the ability to say, which will make sense to some people and not make sense to other people, that an otherwise irrevocable trust, meaning a trust that was living during life but now became irrevocable, or an irrevocable standalone trust, a gifting trust, a SLAT, a spousal lifetime access trust, or other types of irrevocable trusts, a life insurance trust. Now they can be modified. And many of you are aware of this, many of you are not. So statutes can allow this, and possibly even beneficiaries can change or eliminate a grantor's intentions or a testator's intentions under a will that establishes a trust. Now, the question is going to be throughout the rest of this webinar, how do we manage this? How do we think about this? So there are things now in the law that we need to discuss. Trust protectors, decanting. Many of you have seen our decanting workshop or have watched other materials on decanting. Remember that decanting is the substantial amendment of a particular trust that is already irrevocable, or many more often it is the creation of a new trust to replace the old trust. A non-judicial settlement agreement, that's a mouthful. A non-judicial settlement agreement. This came out in, 2016, 2018. This is a more informal way of being able to amend an irrevocable trust by mutual agreement. And it has its advantages and it has its limitations. Directed trusts and unitrust conversion. These are just a few things that we can talk about this morning. Choice of law. This is another trend, okay? You may note that early on in our discussion, I mentioned that we feel privileged to be able to be a resource, not only about Maryland law, but multi-jurisdictional issues. So I think good estate planners today, and I think the top estate planners in Maryland, fortunately, really understand this issue, that there are jurisdictional issues about where it's best for a trust to be administered. Maryland is not the end all. Our trust laws have become much better. And I think the Estates and Trusts section of the bar, of the Maryland State Bar Association, has done a wonderful job to really be on the front end of change. And I am so pleased with the laws that we have now in Maryland. However, our state laws are not the only laws that can be invoked. So other state laws, for example, should a grantor invoke Delaware law to limit modifications or another state's law? So we want to just be cognizant that we are not in a kind of a microcosm here. We are in a big world of multi-jurisdictional planning that's available to your clients. And of course, we don't want to run amok with that and confuse clients, but I think it's a good idea to make sure that clients are aware of these things. Now, trust protectors, for example, as I mentioned, they've been around in Maryland since 2014. This firm has been using the concept of trust protectors since, I'd say, about 2005, or me as an attorney, I've been using these concepts since 2005 or 2007, mainly because I tried to educate myself on these issues and not be inside of that bubble of Maryland. And I think that if you are having a relationship with other law firms, and there are great lawyers out there in Maryland, I want to say that if those lawyers are keeping themselves abreast of the multi-jurisdictional issues, then you are dealing with the kind of lawyers that really will serve clients in that regard. But in Maryland, a trust protector must be a fiduciary. It is basically a power to direct the trustee. And I know many of you by now are familiar with trust protectors. It's a power of amendment, okay? The question really is, can you opt out? So the counterintuitive thing about this presentation this morning, and thank you for your patience as I worked through this. The counterintuitive thing this morning is to say, okay, I realize all these things are out there. And if you didn't realize it, well, then that's a great thing for you to walk away with today. But the other counterintuitive thing, or the counterintuitive thing is, should your client not want this? Is there a reason why the client doesn't or should not want this? Now, I personally think that a trust protector provision or a trust protector idea for most clients is a good thing. I don't see a downside other than the client's own comfort level. I don't see a downside with a client inserting a trust protector provision for flexibility. My concern is, gosh, if we don't have some basic flexibility, what are we going to have in the future? Excuse me. So regardless of how I feel about it, a client has to be comfortable with the idea of a trust protector. So can they limit this? And I think the answer is an open question in Maryland. Trust protectors are authorized in the law, but I think a client could attempt to carve out a provision that says if they expressly never want a trust protector, not only now when they draft their documents and amend their documents in the future prior to their deaths, but they could also say, I do not want a trust protector specifically included in any kind of amendment to my trust in the future or to my beneficiary's trusts. Can you limit the powers of a trust protector? Yes, you definitely can limit the powers of a trust protector. The question is, should there be a carve out or an opt out of a trust protector? Now, again, I'm not a believer in carving out or opting out of trust protector powers, but your clients have the ultimate choice to choose. And I think they can make robust efforts in their documents to be very specific about these kinds of things. And as you can tell, these are rather new concepts to start talking to people about to make sure they realize they can highly customize their documents. In some cases, they can carve out. In other cases, they may not be able to carve out. This is a question of state law. Now, decanting is in 23 states, and there are 2 states that have decanting by what is called common law. So if everybody agrees, we can do this, and that's kind of similar to a non-judicial settlement agreement. So in Maryland, I'm very pleased, as many of you know, in October of 2023, we now have a wonderful decanting statute where if there is an existing irrevocable trust, these trusts can be modified, they can be molded slightly differently, they can be changed to a new trust with limits. There are limits, okay? And the good news about Maryland's decanting statute is that it has a big emphasis on special needs planning. Well, we must have 3 or 4 cases right now at least where we are evaluating the decanting options of a particular irrevocable trust for various reasons. So I just want to encourage you that decanting generally is a very good idea. However, what if your client says, wait a minute, I'm really worried about this decanting statute, right? I'm worried that 23 states allow decanting, and my trust that I have created for my child, I appreciate, or my niece and nephew or grandchild, I appreciate that these trusts have flexibility. I appreciate that, but I am really worried about this and I don't want it to be able to be changed. Well, in Maryland, you can't carve this out. So you can't say, hey, you can't decant a trust. Now, probably the minority of your clients would ever say something like this, but you are going to have people who say, oh, wow, I didn't know that. First of all, I didn't know that we had all these options. And I certainly didn't know that I could limit them, okay? Or maybe I can't limit them in the case of decanting. Okay, so let's just talk about this. powers to change beneficiaries, powers to modify documents, powers to modify powers of appointment, and then I mentioned special needs. I mean, decanting is a powerful tool. The thing I like about the Maryland statute is it's pretty straight down the middle. It's not outrageous, and it does provide us with nice flexibility so we don't have to use Delaware law or Virginia law or other state law. We have ourselves the ability to do a decanting. But let's talk about this issue of no carve out, okay? Client can't opt out of this, okay? But I believe what the client should do is they should recognize that there is such a thing called decanting. So in our documents for years, we have had a provision that says that there is such a thing called decanting, that the client does want to kind of set the parameters of what they feel is appropriate for decanting. It's a conversational issue. It's a client comfort issue. Now, the truth is, most of your clients are going to say, this decanting is a great thing, especially for your families that have loved ones with disabilities. This is going to give them a lot of comfort, okay? But what our discussion is today is when you educate clients and they realize these things are out there in the law, they may not always think this is a great thing. So they do have the ability to address it. Yesterday, I was talking to a client who says, I don't care about this, but I really care about this, this, and this, okay? And we can't completely limit decanting. We can't carve it out, okay? But what we discussed was that this particular client and your clients, through a letter of wishes, this is a memorandum that can be attached to the back of a will or trust, through this memorandum of wishes, which is a letter of wishes, I should say, which is an informal set of instructions, your client can discuss these issues, how they feel about it, and they can try to say, it is my intention that these things should not be done. So in other words, not only a strong interim clause or other types of strong language in the trust or will, but also attempting, even though they cannot expressly limit or carve out decanting, that they could say their wishes and thoughts and feelings and values. And as we're going to talk about in this workshop in the time that we have left, make sure who the selection of the fiduciaries are. Because as I was discussing with someone yesterday, if you're worried about this particular person bringing this action or being problematic, you better not appoint them as a fiduciary where they have powers as a trustee to do decanting, to do these other things that are very overt. So the selection of fiduciaries, I think, is going to be key, especially if a client cannot carve out certain things that are now in the law, things that are seen as very advantageous, but may not be in the eyes of that client. We want to be very careful who the trustee is. Jeff, I'm going to take a look at my clock here. It looks like I better hurry up just a little bit. Any questions I should know about, Jeff, or should I send out a virtual infusion of caffeine?
We do have a couple questions that just came in, Steve. We could pause for just a moment and then we'll move on. So first question is, what does it mean that a trust protector must be a, quote, fiduciary, unquote? You say in Maryland, also in DC, question mark.
Thank you for that question. So a trust protector has to act in a fiduciary capacity. Believe it or not, there are certain powers in the IRS code, if you haven't heard about this, that must be exercised in a non-fiduciary capacity only. For example, when adding a charitable beneficiary under one of the grantor trust rules, that has to be done in a non-fiduciary capacity. So, but Maryland says that, listen, if you or your friend or your family member, and it usually should not be a family member, by the way, it should be an independent person. That's not always the case. A lawyer, CPA, if you are acting as a trust protector, you have fiduciary responsibility. You cannot act arbitrarily. You cannot just get rid of a trustee. If you have the power to remove trustees, you can't get rid of them because you don't like them. You have to have a very, very strong reason to do what you're doing. You have to be transparent, and you have to act in the grantor's interests, you have to further the grantor's intentions. That's my best definition of fiduciary responsibility for a trust protector.
Thanks very much. And one more, could you give a scenario for when a client might want to limit a trust protector's authority?
Yes, thank you. So trust protectors can modify documents. They could modify a document to add a power of appointment or change a power of appointment. Usually that's a good thing, right? Because if someone is going to be subject to, let's say, a generation skipping tax because they have a limited power of appointment, but the trust protector could add a general power of appointment. But those kinds of things, plus let's say that somebody said, hey, I want to give a trust protector the power to mediate disputes. You know, I want to expand the powers versus I want to limit the power. So I think that kind of the two basic powers of a trust protector are to remove and replace trustees and the power to amend a trust administratively for taxes, ambiguities, or other esoteric reasons having to do with administrative things. So I think that is probably the definition of limiting a trust protector. But when you start seeing more advanced trust protector powers, which Jeff, if you would make a note of this, I'm happy, sir or ma'am, if you would email me, or Jeff, we'll send you an example of some expanded trust protector powers. And I think those are the ones that you want to think about limiting, because not all of those are always going to be desirable. But the two fundamental ones are the power to remove and replace and the power to amend a trust administratively.
Okay, Steve, thank you. Very well said and noted.
Thank you very much. And thanks for those questions. A non-judicial settlement agreement can't always be limited. So let's talk about this. Can we carve them out or block them in Maryland? No. But let's talk about this because this does get some people worked up a little bit. A non-judicial settlement agreement is kind of a wonderful thing in the sense that it basically says that, and I'm summarizing, it says that the qualified beneficiaries and the fiduciary of a trust, the interested persons, so to speak, they can agree to some change. So let's say that there is a trust and it needs to be modified slightly. Well, everybody can agree by mutual agreement. A new agreement can be signed, and the trust, voila, the trust is modified. Well, the limit of this, the limitations of a non-judicial settlement agreement are that the people involved that are agreeing, they can only do what a court could have done. They can only do what a court could have done. And so who knows, right? I mean, we're not jurists as far as being judges, and you know, we're not on that kind of level of the judiciary to be able to try to guess. I mean, we kind of know what the limits are. So there are limitations here about what actually could be allowed. So let's say that people agree to modify a trust, but then we find out 2 or 3 years later that they overstepped. And we see this sometimes with people coming back later and saying, well, no, you were not allowed to do what you did. I saw a case recently where a lawyer said, hey, let's just have everybody agree that this can be modified. But the trust was written so tightly that what this lawyer did was beyond the limits of what would have been allowed and what would have been allowed probably by a court, considering what this trust said. So non-judicial settlement agreements, and we've done some in Delaware, we've done some in Maryland, they can be a nice tool, but they are not possibly as good as decanting because of the limitation. But we want to be mindful that this is a good tool. We don't want to just say, no, it's not. Remember, the people that are involved can represent the interests of others, like non-vested minor children and unborn beneficiaries. So this issue of virtual representation by these people that are making these decisions is recognized. But you can just see from that you'd better be careful, right? If you are engaged in a non-judicial settlement agreement, that you are speaking for the interests of others down the line. You'd better be, making sure that you're not overstepping your bounds. So, can non-judicial settlement agreement be carved out in Maryland? No, but I try to assure clients that even though it can't really be opted out or carved out, it has limits. So again, I go back to the memorandum of intent, or the letter of wishes, I will say, and also putting strong language in the trust about one's intentions. Unit trust conversion. So this can be carved out, okay? This is for the situation where a beneficiary wants only a certain percentage of accounting, the testator only wants a certain percentage of accounting income to be distributed, and a beneficiary wants to defeat that, okay? So if one of your clients wants this unit trust provision, they have to be very specific about saying, no, this cannot be changed. This cannot be, this cannot be, my wishes cannot be changed. So directed trusts, so for example, directed trust has to do with shifting fiduciary powers. Somebody says, well, I want a directed Delaware trust. I want to get one of those 50 or 100 trust companies to be the trustee of the trust. I'm basically shifting the power to a new trustee, changing the fiduciary, changing the institution, expanding the powers of the advisor and so forth. This is created by statute. So these kinds of things that most clients are not going to be able to visualize how this kind of thing can happen. But for example, this is a method of invoking Delaware law. So these kinds of multi-jurisdictional issues exist. You just need to be aware of them. And the question is going to be for clients, do we care, do they care that these kinds of things can happen after their passing? So we put out a newsletter, and I know many of you have newsletters of your own. You have data feeds from your various broker dealers, client alerts. We send those out, such as the CTA, which many of you are aware of. Legislative updates. We're getting ready to get a series of legislative updates, and we're waiting to hear what officially has happened in Annapolis. There's been a lot of speculation about the reduction of the Maryland estate tax exemption, but many of us feel that through the grapevine, we're hearing that that's not going to happen right now, which is probably a very good thing for Maryland, considering, but we won't know, and I don't know right now until the end of the month. So just be aware that we will be putting out a legislative update, and many of you will see the various firms that put out legislative updates, and all of those are valuable. Morris Klein, who is an of-counsel attorney to Elville and Associates, Morris keeps his finger on the pulse, as does Lillian Hummel, who is in our Rockville office. Lillian is an heir apparent to Morris and his legislative update duties that he has performed for the Maryland State Bar Association for many, many years. So just know that these are forthcoming. So as we think about maintenance and updating versus post-mortem control, and again, what does this mean? What do we do to make sure that our will or trust can't be challenged, especially if we're worried about that? We can bolster that. We can really put some substance in there compared to the ordinary average inter rem clause. Memorandums of intent, being very cognizant of who the fiduciaries are going to be. So we want a consistent review and looking at the plan, similar to the situation I was describing yesterday. The key question on this whole thing today, and this whole genre, is how much flexibility should we have, or do we want post-mortem? Now, many clients, just like your clients, are worried about their investments right now. Many clients in estate planning are going to say, when they come in, they're going to say, I have got to get this estate planning done perfectly. I've got to get it done perfectly right now. And they put an enormous amount of pressure on themselves. So I spend a lot of time, and so do the other attorneys and staff here, trying to make people relax and realize many people are living long lives. Many people are living long lives. Tomorrow is not guaranteed for any of us, but many people are living a long time. So when the client comes to do estate planning, They are going to do the best estate planning they can do now, based on what they know today and maybe tomorrow when they come back in. But we don't know what the world is going to be like 5 or 7 years from now, 10 years from now, 17 years from now. All we can do is plan today. If what we know today is what we know, and that's the tools, the knowledge that we have to do planning today, how much flexibility based on what I know today would I want in my post-mortem planning as I envision it in the future? What will help clients is to understand that by maintenance and updating, most likely, depending on their age and their health, they will have another 2 or 3 times during their lives, or as many times as they want, to relook at this plan, not just today. And that will take the pressure off of them. That will give them a sense that they can make their estate planning work the way they want, and they can continue to look at these issues. When you think about the fact that there was no flexibility 20 years ago in the law, basically, and now we have these tools, can you imagine what the law will be like 10 years from now? So clients need to be aware we're living in an always evolving world. They will most likely have a chance to look at these issues more than once throughout the rest of their lives and be able to continue to decide how much flexibility, how much lack of flexibility do they want to put into their planning, including the increasing use of multi-jurisdictional type thinking. So, as I mentioned to a client yesterday, be careful who you appoint as trustee. If you don't want a lot of these advanced techniques to be used, one of the first things you can do to try to control that situation is choose your trustees very selectively. Choose trust protectors and give them a sense of what you want. If you see a trustee who is going to do decanting and you don't want decanting and you can't really carve it out, well, we need to change jurisdictions for the administration, or we need to choose a trust protector who will not allow that trustee to do certain things that were not something you intended. Now, the trust protector's job is not easy. A lot of people are serving as trust protectors. I serve as a trust protector on a lot of trusts. It is not for the faint of heart. A trust protector who had to make such decisions is going to have, some risk there because they are acting as a fiduciary, but the trustee might not be happy about being removed. My point is that building flexibility, reasonable flexibility, and thinking through the issues, that's what we're here to do. Personal representatives, we have to be careful who we are choosing as our personal representative. Should clients opt out or try to opt out? Well, in some jurisdictions, they can opt out. In some jurisdictions, they cannot for these tools. So what is the client's goal? That's always the issue. Does that goal require future flexibility? Well, probably does. So why would they opt out? Okay, so we just want to get that on the table. We want clients to know that they can try to opt out of some of these things. They just don't have to take our word for it, carte blanche. Even though someone like me has had 15 years to get my mind around the need for trust protectors, the need for all of these flexible tools. But again, some clients would like to restrict future flexibility. In my example from yesterday's meeting with a client, it turns out that they don't really necessarily care about limiting the future flexibility, even though they want to, probably. Their biggest concern is just making sure that their administrative trust, when they pass away, they want to make sure that they've done everything they can possibly do to discourage a contest. So we have the pre-death issues and the post-death issues in this whole notion of making estate plans work from this particular perspective. So we want to come to terms with these modern tools. We want to know that plans need to evolve. We want to talk about locking in planning versus taking a deep breath and saying, maybe there's going to be a lot of flexibility in the foreseeable future because of changed circumstances. That's probably going to be 85% of your clients are going to see it that way. And we're going to have continuing changes, continuing challenges to come. I don't need to tell you that here in the next 4 years and beyond. Now, as we wrap up on time, I'm happy to say, and get you back to what you were doing or get to lunch, I just want to say thank you again for allowing me to present. We want to be a collaborative resource to you. If we haven't gotten together for breakfast or lunch, let's do that. COVID took so many of us away from each other. I know that was a long time ago now, but some of us are still not getting out like we used to, like we should. So we want to meet, shake hands. We want to see if we can work together for the mutual benefit of clients, collective benefit. We want to help clients discuss their planning, let them be educated on all these things, not confuse them, but educate them in a positive way. Review their existing documents. For those of you who have clients that need their documents reviewed and they just haven't had them reviewed in many years, we generally don't charge for a basic foundational document review. So if you need documents reviewed, let us know. If you would like to form a study group, we used to do a lot of study groups. It's something that could be a benefit to you or your referral collaborative resources professionals. So we're happy to do that or talk to you or your manager about that. And we can talk about preserving assets under management and long-term strategies like that. And we commend you for your commitment to education and for being here with us and listening to us and also collaborating with us. So we want to help you, Jeff. I'm going to turn this back to you. I want to thank everyone. I hope you had a wonderful Easter. To me, it's still Easter week, before and after. So enjoy the day and, in other words, have a great day. Jeff, I'm going to turn it back to you. Jeff, I hope you can hear me, and I hope I didn't go away.
Steve, I'm sorry. Yep, I just have to unmute myself. This is my first webinar, so.
Thank you. I just wanted to make sure that we didn't lose everybody.
No. Say once again, briefly, thank you so much, Steve. Lots of great information, and you piqued the interest of a lot of people with especially the expanded trust protector discussion, and we have some information to send out to several people, so I'll talk to you about that. So as we move forward with our webinar series, we have a couple of really great presentations coming up. This Friday, we have our principal attorney in Rockville, Lily Hummel, and a chartered special needs consultant, Courtney Haycoop, talking about special needs planning, financial and estate planning in unique circumstances. So that's part 2 of a 3-part series that's been very popular. And then May 9th, we have our wellness series with Dr. Michelle Fritsch, talking about ever-evolving scams out to get us. Don't want to scare you with that, but it's not meant to scare you, but really educate you about a lot of the things going on out there. That's an ever-evolving crisis, I would say, in the communities these days. I'll always send the video out and the resources that Steve mentioned, as well as the slides again. And like Steve mentioned, I'll always encourage and welcome the opportunity to get together or back together with you if it's been a little while, to see how we can work together to best serve clients. So let us know if we can help you further, and really appreciate you being here today. And we'll see you again soon on the Elville webinar series. Have a great day.
Thank you.